That's the first question, which means because he's a solicitor, and I'm speaking from as a lawyer. We do work every day. We defend our clients every day. We go to court. Amir and I, we do criminal work. We go to court every day. How can a lawyer be charged for representing his client? So my first question is that. And my second question, I'm sorry, I'm going to break the rule. I'm actually going to ask something outside Sosma. I really would like to know, how are you? Thank you very much. Yes, sorry, Stephen. Sorry, I'm just special for Tan Sri today. Thanks.
Okay, I'll just answer directly. One, the first issue, I will not give you my views at all because the matter is before the courts. And as a matter of policy, I do not make my views on that. Okay. On the other issue, how I am, I'm okay. I'm on dialysis 3 times a week. I still do read. I still do work, and I'm not in the office. I do work like looking after my grandchildren. Oh yes, and sometimes entertaining my good friends around here, or rather they were entertaining me, and some other friends too. That's it. But well, I am functioning very well. I have no issues. But bear this in mind, when I was sitting there in the office too, I was already on dialysis, and I think I had some dealings with the president and past presidents even when I was in dialysis. So I'm okay. You see me?
Yes.
I'm all right. Thank you. I act like any other ordinary lawyers. In the capacity of an AG, I give advice, just like any other lawyers, and we take instructions from the client. Okay? And it is your parliament that pass your laws. Bear this in mind. I'm not responsible for electing your MPs. You are. Okay? Whatever it is. But that is the case. You have your MPs, the laws are there, your MPs voted for it. But if you ask me whether it's unfair or not, I will say this to you again. Sosma is needed. I don't go further than that. However, it is how you interpret and implement it. I think that is the question. There may also be flaws in it. I'm fine. But as we all experience, laws will be amended to take care of these things along the way. Thank you.
I just want to find out if you bring a charge against the Prime Minister, is that detrimental to parliamentary democracy and is it applicable under Sosma?
Kafai, just one more question.
Very short question. Kafai from the bar. My question is specifically to Tan Sri. Now, the Sosma offers a different rule of trial, in a trial court, as opposed to a normal CPC rule of trial. So, these Sosma special rules of trial violates all the fundamental human rights. So, my question is, in your view, is it okay to violate those human rights, those fundamental human rights, just because a person is expected to be a terrorist? Thank you.
I think there's a couple of questions there for Tan Sri. Maybe Tan Sri can start first.
I'll answer your question first, the last one. But the issue is very simple. You look at Article 149. It says, to the exclusion of Article 5, 9, 10, and so on. Okay? When such situation occurs. But the rule of thumb is this. What is that situation? It would indicate that the threat is ongoing and something has been done. And the threat is very, very, shall I say, it must be of such a nature that you need these particular laws to address it. Otherwise, you will not be able to address it. Let me give you an example. Like the attack in Lada too. If you were going to apply the ordinary laws, it will not work. Let me put it this way. Nobody wants even to go down there to collect evidence while the shooting is going on. Who is going to collect the evidence? Who is going to record statements? Okay? That is how bad it can be. So those are the kind of situations I would think a apart from other things too. Now, you must also remember this. Your enforcement agencies are only as good as what they can perform. And they must be given the authorities and certain powers to do their work. But again, if you were to ask me, by the end of the day, you ask any lawyers for that matter, even an arrest, they will say no. Why do you need to arrest? You investigate first and charge the person. But why was everybody accepting that 24 hours? Strictly speaking, that 24 hours detention is also denying you of your freedom. But that is acceptable. Why? Then we saw the white-collar crimes. I've always said this, white-collar crimes, investigate first before you arrest. Do not arrest. Okay? But what is the distinction between white-collar crimes and other kinds of crimes? Theft, for that matter. And to the victim, if you don't arrest the person, I can tell you, the victims will also raise hue and cry. But in answer to your question directly, if the laws, the federal constitution provides for that exemption in such situations, then it can be provided. I have no views about what is fair or not. My views of what is fair is in accordance with the federal constitution and the laws. And if the law is not fair, is contrary to the constitution, then it becomes an unfair law. It's very simple. By the end of the day, the Bible is the constitution.
Whether Shannon, what was your question?
What was your question?
Can you repeat? Security offences. Yeah.
It's about whether all acts considered detrimental to parliamentary democracy fall under Sosma.
You have to read 6 and 6A carefully. And normally, if you look at the part, it's offences against the state, not against individual. Okay? So you look at the penal code, it's very nicely crafted. It's offences against state, offences against person, and then injuries, property. So you can see this and what it's for. I think I'm very clear on that. Thank you. Just to add in, to be fair to all parties, the Attorney General's Chambers, together with the bar, had this going on, what we call the Yayasan Bantuan Guaman, which YBGK, which we believe, both sides believe, that everybody should be represented. So at this moment of time, we had, I think we have all the Malaysians, anybody arrested to be represented. And also, I think we extended it to children of foreigners. Yeah. We have extended to that until I left the office. But that shows the concern by both the government and the Majlis Peguam on this representation. But remember this, the difference with Sosma and ISA, it was like they can try to take you in, they didn't even allow the lawyers, but in this Sosma, within, I think 48 hours, they must allow a lawyer to be there. It's 48 hours. So it's not as if the arrested person is not going to see a lawyer. He has the right. Thank you.
Thank you, Tan Sri. There's one.
This is directed to Tan Sri. Considering the fact that POCA, POTA and Sosma has been used together to counter terrorism in Malaysia, from the Aegis Chamber perspective, is it necessary? From your opinion just now, I think you made it quite clear that the Sosma is a very good legislation on its own. If so, why do we need POTA and why do we need POCA to handle terrorism? The second question is, if you look at the recent case of Ardin Farizi, the alleged IS hacker, it was said that the public prosecutor requested for his arrest because there was an extradition order by the US government. But he was arrested under Sosma. Procedurally, is that acceptable?
Let me put it this way. First of all, as a professional, I cannot comment on something that I do not know the details. I wouldn't be able to. And to make comments when I do not know the facts of the case, exactly what went on, would be wrong. However, on the first issue you raised, okay, whether needed or not. Let me put it this way: the applications of those laws, detention, for investigation, are not within our purview. That is for the enforcement agencies to decide. We don't cross over to investigate. That is not of our business. They will have to put their mind as to what is fair or not and apply those laws. And that is their duty. By the end of the day, what was the safeguard? Remember just now I mentioned, before the 28 days expire, they must refer to the public prosecutor. Then the public prosecutor, that is the safeguard. Only then it comes in. Otherwise, no public prosecutor has the right to disturb any investigations now, as far as I'm concerned, during my time. Okay? It has to be done that way. There has to be separation of powers. Thank you.
Just now he mentioned it as if like we are the one who make law and Tan Sri just execute the law. But everyone who knows this country know the reality is his office made the law, submitted to the chamber in parliament, and as oppositions, we have no chance to amend even one titik comma or full stops of the law. So, and clearly, as Hybridins and Matthias Chen case show that the law has defect and it allowed the executive to abuse it. I would like to know if Tan Sri have a chance to rewrite the law again, whether there will be more safeguards built into it. And as we were debating, we made clearly that we agree with the Bar Council. The law has a lot of defects. The law allowed the executive to abuse. Despite the Prime Minister's guarantee, we said the same thing. It was just like the ISA. It was guaranteed that it was only used for subversive, but at the end they used it. And it is so fast, within such a short time, we have seen the abuses. So I'd like to hear from Tan Sri about his possible amendment to the law.
I will say this to you, with respect, of course. In the first place, I've always prided myself to be neither a politician nor a diplomat. I call a spade a spade. In the first place, I've never said exactly that, oh, these are abuse. Yes, I didn't. Remember what I said. Until I know the facts in detail, only will I make comments. That has been my job all the while. And to prove abuses, you all know that it has to go beyond reasonable doubt. As a professional, no matter what you are, lawyer or in the prosecution, you hold by that principle alone. Otherwise, you are of no use. Otherwise, you fall within the category of others I will not mention. On the whether I will amend the Sosma or not, let me tell you the processes of how laws are drafted. Yes, the Aegis chambers will draft the laws, but these are all promoted by the various agencies. If the Attorney General's office do not simply put up laws on their own, no. And what is the other process? If it goes on, after that it has been drafted, they discuss with all the various agencies, everything has been put up together, this paper will be put up to the cabinet for approval by the minister himself. So the minister will put up to the cabinet, that will be approved, and then it will be sent to the parliament. And yes, maybe, I'm not too sure who voted for or against, but by the end of the day, it is Parliament who passed. I think that is the issue. I will not cast aspersions to you, Ivy. At the same time, whether you voted or not, I will not say that. I do not know, actually. I do not know. All I know is that Parliament passed it. But I cannot say, oh, Mr. So-and-so voted against it or voted for it. I can't say that. But what I can say in that is, generally, I think these kind of laws, the opposition will not support. Is that fair enough? Thank you.
Granted that we have a decision, the Robert Ligi case in Sabah. There was a High Court decision that completely changed the landmark of locus standi in Malaysia. And subsequent to that case, we've got, of course, the case of Patail and Manoharan. That is a Court of Appeal case approving the Sabah Robert Ligi's case that completely obliterated the ruling of the powerful panel of the House of Lords in the case of Goret versus Postal Workers Union, I believe. It changes also the test of locus standi in Lim Kit Siang versus Government of Malaysia in the 80s. That is to say, today, Malaysia has the most flexible local standi test anywhere in the Commonwealth, if you look at it. So the question is very simple. Granted this new judicial activism, refusing to follow even English rule on local standi, that is to say, anyone can come forward to the courts by saying that a particular law is against the Constitution, and that's good enough. The question that was formerly not allowed by the courts, if it is not this man, who else can sue? That apparently has been the order of the day. The judge can ask, if not this man, if not this plaintiff, who else can sue the government? Now, the question is this. Can we expect soon that the Bar Council or anyone in this room or any NGO will mount a challenge on the constitutionality of Sosma? That's the question.
Thank you. And we'll take the last question, I think Jackson, right?
Is there really a need to bypass the judiciary for the extension of detention for 28 days? If there is a need, how can it be justified? And secondly, is there really a need to deny the right to an attorney for the first 24 or 48 hours? I'm not very sure. I'm not very clear on it. If there is so, is there really a need? Thank you.
Let me put this way to you. When the 48 hours is given to you, to an enforcement agency, it doesn't mean that he has to exhaust 48 hours for all cases. No. There are some cases within 6 hours or 24 hours they can do it. They will give recourse to an attorney. But in some cases where they need to travel or whatever the distances and all that, possibly they need to retract. That's why they need the 48 hours. So depending on that, and they will have to justify that. Okay? And the 28 days or so, not reference to there are possibly to be investigations especially on serious matters like ICs and so on, where they develop into cells. The issues is that the operations of, I'm not an expert on this, but from what little I know, I can tell you. But I can't tell you everything. But the operations of ICs is entirely different nowadays. It goes in cells. In those days, you arrest one, you will possibly get all the others. Today, you can't. That's the difficulties. There's a lot of difficulties. You have to be fair. After all, it's your own security. Thank you very much.
Thank you, Ranji.
My question is, when it's obvious that it's a wrongful application of an act, can we say safely that we can leave it to the wisdom of our judiciary to throw out this charge?
Okay, thank you. Thank you, sir.
Well, I must say this in a very short. Yes, you have to depend on the judiciary for redresses of any grievances. That is a fact. Okay? Because in the final recourse, you go to the judiciary. Now, on the issue of whether he was charged, I think what you're after is basically this, whether I feel that he has been charged properly or not, whether there is a case against him or not. Again, I have to tell you, I cannot, because I do not know the facts. The only thing I know is that he is a lawyer and he has been remanded or detained under that particular law. That is all I know. And he is a lawyer and, of course, allegedly representing the other person. That's all. Further than that, I do not know what the prosecution have. And you have to be fair to them. That has not been disclosed as yet. We have to look at the trial. If at the trial there was no evidence, nothing, then that is bad prosecution. But if they have something else to prove, yes. A lawyer is not exempt, even the Attorney General is not exempt. Even ex-Attorney General is not exempt from the laws. That is what it is. Okay? So I hope I've answered you. I thank you very much for your listening.